Good afternoon. My name is David Gallo. I'm the director of the AIFC Academy of Law, and we welcome all of you who have joined us today. We are broadcasting from Nur Sultan, Kazakhstan. It's mid-afternoon here. Welcome to all of our guests from the UK, across Europe, the Middle East, and of course, Central Asia. As many of you know, the AIFC Academy of Law has been offering a series of complimentary learning and development webinars addressing relevant and highly interesting current legal issues that we are facing today. First and foremost, we hope that you are safe and that you're well, and we're very pleased that you are continuing the learning and development activities as well as continuing to move your businesses and law firms forward in spite of these unfortunate times. Let's hope that the light is at the end of the tunnel and that we emerge and resume to normalcy sooner than later. I think we're all on the right track. Today's event is part of a series called Fireside Chat with the Experts, Legal Considerations Arising from the COVID-19 Crisis. Well, what do we mean when we say the experts? Well, the AIFC was formed a couple years ago, and its formation was driven in large part by several high-level expert advisory panels. And so in this particular webinar series, which we've called the Fireside Chats, we have representatives from the advisory panel on legal regulatory matters. And at least one of those members is on every one of these lectures. So this is actually part 3 of a 4-part series, and it's called Force Majeure and Frustration by English Law and AIFC Law. Well, before we launch into the introductions, let me just mention that there will be question and answers at the end of the session. They can be both by written chat as well as by raising your hand. Also, we may have some interactive events that will require your engagement, and the moderator, Patricia Robertson, QC, will be sort of managing that aspect of the presentation. The Academy of Law is dedicated to preparing lawyers for international commercial law practice. We're operating in an increasingly complex legal environment. Here at the AIFC, we have a common law English language jurisdiction that has been designed to attract foreign direct investment and create an environment where companies can set up and be in familiar surroundings relative to laws governing their rights and obligations under their commercial contracts. And in the event of disputes, there are dispute resolution institutions here who are able to resolve those disputes in an efficient and fair manner. Now at the Academy, because we recognize that we are operating in a multi-jurisdictional environment, we're looking for ways to cross-train lawyers to make sure that they are adequately prepared to operate here. And we're attempting to provide access to lawyers regardless of their background to participate in the AIFC economic development activities. So with that, let me please introduce today's 3 panelists. The moderator today will be Patricia Robertson, QC. Patricia is a member of the AIFC Advisory Panel on Legal Regulatory Matters, as I mentioned, from the day of its creation, which was in the beginning of 2019. Patricia Robertson, QC, has served a 6-year term on the Bar Standards Board, including 3 years as vice chair. She was also appointed as a deputy high court judge in 2016 and as a member of the Abu Dhabi Global Markets Appeal Panel in the same year. Ben Lynch, QC. Ben is a barrister at Fountain Court Chambers. Ben is a highly regarded junior in commercial litigation. He has a specialist practice in fields of insurance and reinsurance and was the winner of the Chambers and Partners 2017 Insurance Junior of the Year Award, being described in the directories as, quote, the most highly regarded junior counsel in insurance and reinsurance, end quote. Very impressive, Ben. Ben Lynch is highly regarded, and he's ranked in the fields of commercial dispute resolution, professional negligence, and telecommunications. And he has been described, amongst other things, as a barrister with a frighteningly astute mind who doesn't leave any stone unturned. Ben has particular expertise in competition law, cyber issues, fraud, injunctions, international commercial arbitration, regulatory law, professional discipline, and shareholder disputes. And we also have with us today Deborah Horowitz. Deborah is also a barrister at Fountain Court Chambers. She has a broad commercial, banking, and regulatory practice. Recent instructions include representing RBS in the litigation relating to its £12 billion 2008 rights issue, which was one of the lawyer's top 10 cases of 2017. Deborah has also acted for GE Capital, actually my alma mater of 22 years, GE Capital, in its successful defense in the Court of Appeal in respect of a claim brought by Upstream AG for a US $30 million in relation to an aircraft finance transaction. Deborah has also acted in a number of commercial court cases, often with a cross-border element, and her practice spans disputes covering banking transactions, commercial contracts, company law, aviation, regulatory investigations, and corporate crime, including fraud and bribery. She has acted for clients and in disputes in a range of jurisdictions, including Singapore, Australia, Hong Kong, Korea, Bermuda, the Isle of Man, Guernsey, Russia, France, and Italy. And with that, I'm going to turn it over to our moderator, Patricia Robertson, QC. Patricia.
Thank you, David, for this opportunity to talk with your students about an area of law that we can all expect is going to be highly relevant in current circumstances. Now, we're all having to adapt very fast to new ways of doing things. So certainly me and my colleagues from Fountain Court are having to, for example, conduct our trials remotely via Zoom and Skype. And certainly that's a learning curve for everybody. One of the positive aspects of current circumstances, and given we're surrounded by so many negatives, it is important to celebrate the positives, is initiatives like this one, which enable us to exchange ideas and share learning, even though we're across the globe. So I, right now, am sitting in Italy. Deborah is in Australia. Ben is in some of the wilder parts of Norfolk in the UK. And most of you, I assume, but doubtless not all of you, are in Kazakhstan. And yet we're able to come together to discuss these issues. But obviously, COVID-19 also brings with it many negatives, both personal and economic. And our focus today is on some of the legal consequences that are most relevant to businesses. Right now, there are going to be companies around the globe asking their lawyers some difficult questions. Whether they are released from their contractual obligations because of COVID-19, and at the same time, somewhere else around the globe, the contractual counterparty is asking the same question, but hoping for a different answer. In other words, hoping for the answer that the contract is still enforceable. Can we have the next slide, please? Thanks. So here's an outline of what we're going to talk to you about. We're going to start with how English law answers those questions. Sorry, that is what we're going to talk about. How does English law answer those questions? But I'm going to start with the question of why is English law relevant to you from your point of view as individuals who are studying or practicing in AIFC law. Ben is then going to take over and look at how the English courts have interpreted contractual force majeure clauses. Deborah is then going to compare that with the English law doctrine of frustration, which can bring contracts to an end where the parties themselves have not expressly provided for the situation in their contract. We're then going to say a bit about how we anticipate COVID-19 might impact different industry sectors, giving scope for arguments about how these English law doctrines apply and potentially generating some litigation that might end up in your AIFC court. We're going to make some brief comparisons as to how different jurisdictions are addressing the impact on contracts. And we're going to end, as David has said, with a Q&A session. So please feel free to type in your questions in the chat function and we'll come to them at the end. We also have, if we have time, an interactive session for you. Can we have the next slide, please? So what is the relevance of English law here? The AIFC has, of course, its own regulations relating to contracts. And I'm going to come in more detail to some relevant parts of those regulations in a moment. When the AIFC court is dealing with a dispute about enforceability of a contract in current conditions, it will need to decide how to interpret and apply those regulations to the situation. Now, the AIFC court's own regulations make clear that the court will look at how other common law jurisdictions have addressed similar situations. English law has been quite influential on the way that other common law jurisdictions have developed. The drafting of the AIFC's own contract regulations, as we're going to come to, has been influenced by English law. And that's not surprising, since as I understand it, a number of English lawyers were very much involved in assisting the AIFC to put together its legal framework. Many of the judges in the AIFC court are English, and therefore English law is the common law jurisdiction that they are most familiar with. Therefore, when they come to interpret and apply the AIFC contract regulations to a dispute, English law will provide them with a well-developed body of existing cases that have addressed whether contracting parties are released from their obligations by various other types of extreme circumstances. So the way that English law has analysed this sort of question is likely to be highly influential in how AIFC law develops. Can we have the next slide, please? As I expect you already know, AIFC has put together a set of regulations which apply specifically to contracts that are governed by AIFC law. And these include making express provision for force majeure. That's Regulation 82, which you have displayed up on the screen. Now, first of all, notice that this does not apply to payment obligations. Now, that is consistent with the approach that English law takes to force majeure and frustration. The fact that you can't afford to make a payment because of the impact of an event on your business is in general treated as irrelevant. It doesn't make it impossible for you to make the payment. The banking system hasn't collapsed. The currency is still functioning. Your economic condition is not a force majeure event in general. Ben and Deborah will have more to say about how English law generally analyses economic hardship and what exceptions there may be to that general rule. Now, as regards performance of non-payment obligations, the conditions under Regulation 82 for excusing non-performance involve 4 elements. First, there must be an impediment that's beyond the party's control. Second, that must be the cause of non-performance. Third, the impediment must be something the party could not reasonably be expected to take into account at the time of entering the contract. To use the terminology that's used in the English cases, it must be unforeseeable. Fourth, the consequences, in terms of the impact on performance, must be such that the party could not have avoided or overcome them. The impact on the contractual obligations, and this is part 2 of the regulation, will be proportionate to the impact that the force majeure event has on the ability to perform. So, for example, A temporary impact may simply extend time for performance rather than removing the obligation altogether. Can we have the next slide, please? Now, there is an express requirement under Regulation 82 to notify the other party. And the regulation specifies that the penalty for not giving prompt notice is liability in damages for non-receipt. Now, I've seen from the notes from a lecture that Mr. Yelyov gave earlier this month on Kazakhstan court practice on force majeure, that as I understand it, a party who doesn't give notice would be at risk under Kazakhstan law of being unable to rely on force majeure at all. Now, the approach taken by the AIFC regulation is less strict in that it doesn't bar reliance on the force majeure event if you fail to give notice. What it does do is allow the other party to recover damages for steps that they have taken in reliance on the expectation of performance, which they would not have taken if you had given notice of the force majeure event. Regulation 82.4, which you also have up on screen, makes clear that none of this cuts across any other contractual right a party may have to terminate or withhold performance. So, for example, even though payment obligations are not themselves directly excused by the force majeure event under Regulation 82, the other party giving notice of non-performance under Regulation 82 may permit the paying party to withhold performance relying on the contractual terms if the payment obligation is conditional on performance by the party affected by force majeure. As Ben will come on to explain, all of this is closely aligned with the approach that English law takes to contractual force majeure clauses. In effect, what the regulations do is they write into the contract a force majeure clause in any contract that is governed by AIFC law. The parties remain free to come up with their own different clause if they wish to do so, but if they don't, Regulation 82 is what will apply. Regulation 83 seems simply to be underlining the point that force majeure does not excuse a payment obligation. It's important not to lose sight of the question as to whether there is, in fact, an obligation to pay. As I've just mentioned, if the payment obligation is conditional on performance by the other party of their obligations, then unless and until that performance takes place, there is not any obligation to pay. Can we have the next slide, please? Regulation 84 is interesting, and I look forward to seeing what the AIFC court has to say when they first have an opportunity to consider it. Now, if you read it through, it seems on the face of it to be directed to the remedy that a party has for non-performance. It says that they may require performance. Now, in English law, we would call that the remedy of specific performance. That's where the court orders a party to perform their contractual obligations. Regulations 84C and D equate to situations where in English law, specific performance would not be ordered. For example, where the contract is one of a personal nature. Now, it may be that require is also being used in a rather broader sense to include being entitled to insist on performance and hence to recover damages for non-performance. The regulation goes on to identify a number of circumstances where a party will not be entitled to require performance. And the first of these is impossibility of performance. That would seem to be the equivalent of what we in English law would call frustration of the contract. Impossibility of performance is a very stringent standard, but where it's established, English law treats the contract as terminated and both parties are released from their future obligations. Deborah is going to talk about the English law doctrine of frustration. And it seems that those cases are likely to be relevant to how the AIFC court interprets Regulation 84A. 84B is particularly interesting because it goes wider than impossibility. It would excuse performance where that has become unreasonably burdensome or expensive. Now, just how much more burdensome or expensive does a contract have to be before that regulation will kick in? As Ben and Deborah will explain, English law has taken a rather restrictive approach of when parties will be relieved from their contractual obligations by economic circumstances. The additional burden usually needs to be really very extreme before English law will treat it as relevant. But also, English law respects the right of parties to choose to contract on terms that give them more protection against adverse economic developments than would otherwise be the case. By choosing AIFC law to govern the contract, and thereby adopting Regulation 84B, the parties are in effect writing into the terms of their contract a broader protection against adverse economic change than would normally apply as a matter of English law. As Regulation 11 makes clear, they can, on the other hand, choose to derogate from Article 84B. So it's an interesting situation because the presumption is the opposite to that which would usually apply as a matter of English law. If the parties don't provide otherwise, they have a broad protection against economic hardship, but if they derogate from it, they may get closer to the usual English law position, which is that kind of protection is the exception to the general rule. I'm now going to hand over to Ben, and can we please have the next slide?
Thank you, Patricia, and hello to everyone. I'm going to speak for 15 minutes or so on English legal principles regarding force majeure. It is a great topic to be talking about because, first of all, it's a relatively underdeveloped area of the law. There aren't a huge number of cases about it, and the textbooks are relatively thin on it. Secondly, it seems likely in the current economic circumstances there are going to be lots and lots of cases. So there are lots of questions to investigate, lots of interesting points that will come out and no doubt be argued about. The first thing to say is that force majeure in English law is a contractual concept, not a common law principle or a statutory concept, other to one tiny or small, relatively small extent for remedy. So what I mean by that is that there's no, if there is no force majeure clause in your contract, a party who would want otherwise to rely on a force majeure concept can't say, I rely on force majeure. They have to rely on frustration, the principle of frustration, and Deborah will cover that. But that is an immediate and obvious distinction between straight English law and the AIFC position, because the regulations stipulate for force majeure themselves. The next question in English law is, well, do you have a force majeure clause? If so, what's it say? And the function of that clause will be to set out in what circumstances a party will be excused from performing a contract where events outside the party's control prevent performance. And we compare that with AIFC Regulation 82. And again, I just make the point that you have the regulations. The question is whether or not we have the clause in the contract at all. The next big distinction between AIFC regulation and English law, which is both a distinction but also helpful in terms of understanding why English law is helpful in the approach to AIFC regs, is that the question is, in English law, do you have a clause? Next question, what does it say and how is it properly construed? And that's a major theme that I want to draw out as we go through this, which is that the regulations under Regulation 82 are relatively prescriptive in terms of what the regs say. That is then tempered to an extent by Regulation 84, which is interesting, as Patricia's already covered, appears wider and appears to add some flexibility. So immediately we see that whilst there is this distinction between English law, is there a clause, isn't there, what's it say, that is then fed back in to an extent in the AIFC regulations by the flexibility permitted under Regulation 84. So imagine in English law that we do have a clause. We wouldn't be talking about it if we weren't. What does that clause say? What does it do? First thing it will always do is define a force majeure event. And there, it's literally a question of what it says, and the court has to construe the contract. Invariably, the parties will define what they mean by force majeure events. And what the parties sometimes do is just have wording similar to Regulation 82, which is any other causes beyond our control, or any cause beyond our control. More often, the parties have a very long list of everything they can conceivably think of that might amount to a force majeure event, so strikes, government intervention, pandemic, etc. The problem with that is, as you'll all no doubt know from your practice or study, the more specific one is on a list, the more it looks like you're deliberately leaving something out. So many of these clauses do not contain pandemic wording. Now, that's a big problem for obvious reasons, because people want to rely on the wording and can't, because it looks like they deliberately left out the wording pandemic. But obviously it will depend on the specific wording. Now, particularly importantly for present purposes, the lists often do not include economic hardship or economic downturn or words to that effect. And normally, the courts have said, look, if you, the parties, want to include as a force majeure event the fact that the performance has become economically more burdensome, then you have to write that in. You have to include that expressly in your contract. Now, that is subject to wording, because theoretically it's possible that the parties may have a form of wording that's sufficiently general that it could be read to include economic downturn or economic hardship as a force majeure event, but that will depend on the wording. Again, contrast Regulation 84B, which Patricia has covered, which very interestingly does already cater for economic downturn. Now, in a time like the present, that's going to be particularly important and is likely, it seems, to give rise to litigation. Next slide, please. So, turning now to the elements that need to be proved. In English law, the burden's on the party seeking to rely on the force majeure event, the force majeure clause, to show that the case falls within the terms of the clause. That's notably the same as Regulation 82.1, which expressly provides for burden of proof. The party who seeks to rely on the clause must prove that ... And the list below that you'll see there is what generally parties have to prove. And the reason why it's generally what parties have to prove is because those are the elements that generally appear in the clause. They don't always. A number of them invariably do. Some of them may not have to, and there is flexibility, and it will depend on the wording of the clause itself. So the first one of the events listed in the clause has occurred. Now that's generally true. The parties will generally have a list of force majeure events, but not always. They might, for example, have something similar to Regulation 82 itself, which just has a catch-all, which is matters beyond the control of the parties. But obviously that has to occur. Then the event caused the party to be prevented, hindered, or delayed from performing. Now, there was a very interesting seminar given recently by a leading academic in England called Professor McKendrick, and he was asked a question about this, whether or not causation is a requirement. And the short answer is, again, that will depend on the terms of the contract. Theoretically, and because I've never seen one myself, but there may be some out there, instead of saying that the force majeure event caused the party to be prevented, hindered, delayed, etc., there could be weaker causative language. For example, the event could be in connection with or arising from a force majeure event which prevents, hinders, delays. So theoretically, there could be a broader test. The non-performance was due to circumstances beyond the party's control. That's almost always, I think, always going to be the case. I suspect there'll be almost no exceptions to that, because otherwise it won't be a force majeure event in reality. And then there were no reasonable steps that the party could have taken to avoid the event or mitigate its loss. There's almost always wording to that effect in the clause. Often there's also wording that goes further. For example, defining what are reasonable steps. So for example, a seller may not have to go to the market to obtain further goods if they themselves run out of goods, is one example. Next slide, please. Thank you. What we normally see is that the force majeure event must have prevented, hindered, or delayed a party's performance. Now, that is the normal language, but it's not invariably the case. In fact, it is different in Regulation 82 itself. It just refers to non-performance. There is other wording. So, for example, interfered with would be broader, and there are wider words that could be used, and in some cases is used. And what we go on here to look at are the principles of what is meant by prevented, hindered, delayed, but obviously be aware that's just because those words were used. So when the court construed the force majeure wording, it was construing that wording. In a different case, it will construe different wording. So this isn't a straitjacket. This is just, these are the principles the courts have determined based on the wording. So prevented is strict. That means physical or legal prevention and not just economic unprofitability. Patricia's covered that point. Hindered is more flexible, and that will include an interference with the manufacture or delivery from the same cause as preventing, but interference of a lesser degree. And there was a case, Tenants, where the court held that placing a party in the position of being unable to deliver unless he dislocates his business and breaks his contract in order to fulfill one amounts to hindrance, but a mere rise in price was not hindrance. Now, obviously there, on that wording, a mere rise in price was not hindrance. But if you had as a force majeure event in your clause, hindrance caused by unforeseen market interference, for example, then that, depending on the proper construction of the clause, would be sufficient, or arguably would be sufficient. Delayed language, that's relevant where the clause allows for an extension of time if there's delay due to events beyond the party's control. That is particularly relevant in the present day because there are lots of contracts that may still go ahead but are delayed, for example, because of a lockdown. So things are effectively on hold for 2, maybe 3 months. That's a delay, but it's not prevention. But remember, there is other wording that could be used. Next slide, please. A very important point, which will give rise to litigation, I'm almost certain, is the next point, which is it is generally the case, the courts have said that the force majeure event must be the sole cause of the failure or delay or hindrance in performance, in performing the obligation. But that depends on the wording of the clause, and it seems likely that in the present day, and for obvious reasons, there will be many causes. So for a contract may be delayed, for example, because no one's allowed to go to the office because it's been shut down because of lockdown. Equally, there may be a significant economic downturn that causes the company to collapse, or at least be mothballed, put on hold for 2 months. There are then 2 causes. In a sense, both stem from one original cause, which is a pandemic, but that is multifactorial. What if the company was already in financial trouble? That's another cause. And so the sole cause concept, which is dependent on the wording of the clause in each case, is likely to give rise to litigation. We've already addressed adverse economic conditions to an extent. But here, just to reiterate the point that usually this will not constitute a force majeure event unless the parties clearly contracted that effect. And there are a number of cases, Tandrin, Seadrill, the Brower case and so on, where a change in economic market circumstances affecting profitability of the contract or ease of performance will not normally be a force majeure event. But just pausing there, that's because of the wording used. Next, but there is a distinction between mere unprofitability and a change so extreme that it's outside anything the parties contemplated when they made their bargain. And that's, for example, having to incur a cost equal to 100 times the contract price. Now, I keep stressing the point that it depends on the contract wording. Remember, most litigation, of course, that will arise now will be on existing wording, old wording. And no doubt many of us have already been asked to look at current wording and say, well, look, how can we improve this to protect ourselves? The short answer is, in lots of cases, it's too late. The problem has already arisen, the loss has already occurred. We will be looking at old wording. So in lots of cases, there simply will not be wording addressing economic conditions, but obviously be alive to that argument. Next slide, please. So the effect of the clause, 4 points here. First point, the clause or part of the clause may require notice to be served. So that's one party saying, look, there is a force majeure event, I need to rely on it. Invariably, there is something along those lines. And obviously, a breach of that is often a form of condition, even condition precedent to being able to rely on the force majeure event. And so parties have to be very careful to comply with that. Next point, depending on the wording of the clause, of course, the effect will be to suspend performance, extend time for performance, impose requirements to mitigate, render a party not liable, trigger a right to terminate. It's a form of excusing the parties, but obviously be alive, they're not all the same. Some say suspend performance, but you still have to comply later. Others will say you're completely excused of all liability. Others will provide different remedies in inverted commas, but be alive to the difference. Third point, may be that the clause specifies what is to happen to payments already made. If not, fourth point, then the Law Reform Frustrated Contracts Act 1943 may address the question. That's the point on remedy that I said was at least in part statutory. Next slide, please. Finally, relevance to COVID-19. Now, it's obviously going to be very important in the present day for a number of reasons. First, there haven't been many cases in the past, but none of us has ever lived through a pandemic before. Now, a pandemic's come along that has destroyed some sectors of the economy, has prevented individuals from acting as consumers in the normal way, has prevented businesses acting as suppliers or purchasers in the normal way. And that has obvious consequences. A party may well be trying to get out of a bad bargain. A party may be in a good bargain, but simply be unable to perform. There may be a complete drop-off on demand, for example, petrol, which I'll come on to later on when we look at the specific sectors, or there may be a huge amount of demand and no supply because it's been impossible to produce something. I'll give another example of that later. But COVID-19 will, at the very least, disrupt supply chains. That will affect suppliers up and down the chain, not just at the individual link in the chain. It will affect all of them. And obviously, parties in a chain, even if they're not in the chain, just in a normal contractual relationship, will look at their force majeure clauses. Parties will then have to see whether or not the events that affected them actually are applicable. So the original cause may be the pandemic, but that might be so far down the chain that it's causally too remote. Then in terms of causation, was it COVID-19 itself, or was it some other cause? Next question, which we've been through a number of times already, often it will be an economic impact, which is the real problem. Question will be, is that within your force majeure clause or not? So I'll just hand over to Deborah now, and next slide, please.
Yeah, thank you very much, Ben. So just as Ben did, I will adopt a similar structure where I will talk through the key legal principles under English law regarding the doctrine of frustration, and then I will turn to particular implications arising from those legal principles in the context of COVID-19. The starting point when we're looking at the English law and frustration is to recognise that it is a narrow concept within English law. We have the rules regarding force majeure, which Ben has covered, and which cover the field in a lot of situations where you have a force majeure clause. And because in particular of the existence of those clauses, the doctrine of frustration is quite narrowly interpreted. That said, when do you know whether a contract is regarded as frustrated? And the law says this: it will be regarded as frustrated if objectively assessed, a particular event occurs after you've entered into your contract. So you've entered into your agreement and then further down the line, something happens. What does that entail? Well, first of all, the event that comes along has to make it physically or commercially impossible to perform the contract. I'll run through these and then break them down. So firstly, physically or commercially impossible to perform the contract, or it changes the obligation to one that is radically different from that undertaken upon entry into the agreement, such that it would be unjust to hold the parties to the literal terms of the contract. And in that case, the law will declare the parties to be discharged from performance. So as Patricia's mentioned, it brings the contract to an end. So let's break those down. Firstly, you've entered your contract, an event comes along which makes it physically or commercially impossible to perform. Now we can understand physical impossibility in the sense that if you're meant to supply cargo and something happens which renders it impossible to supply the cargo, something extreme, we can understand physical impossibility, a ship in a storm and so on. Commercially impossible, I found interesting as a phrase. That was taken directly from one of the main English law textbooks. And the chapter was written actually by Ewan McKendrick, who's the academic that Ben referred to before. But there's a lot caught up in that phrase because we've been talking about how economic hardship won't often count as an excuse for performance, for example, in the context of force majeure, nor in frustration. So there's a lot packed into that, but that's apparent. That's what the doctrinal position is. But it really, as the second point says, has to be a situation which makes it radically different from the obligation undertaken when you entered into the contract. So if you have a set of obligations under your contract when you've entered into it, and then something occurs which makes the type of performance radically different from what was envisaged, that will be relevant for frustration purposes. As Patricia's also identified, the idea of impossibility is embedded into the AIFC principles as well. So there's an alignment with the English doctrine here. Thirdly, it has to be unjust. Well, it would be unjust to hold the parties to the literal contract. So the impossibility plus radical difference tests lead to this unjust concept. And then fourthly, as I said, the consequence of this is that the parties will be freed from performance of their obligations. So this has a big impact. And just returning to that narrow application point, which is the second point on the slide, courts apply this narrowly because they don't want parties to take advantage of it. Imagine if you have some big contract and suddenly things have just become harder for you to perform. So you might want to come along and say to a court, sorry, it's just harder for us. We don't want to perform it, or it's impossible for reason X, Y, or Z. The courts will say, no, we're going to construe this very narrowly. So contracting parties can't simply try to get out of an obligation simply because it's become a bit more difficult. The test really is impossibility and radical difference. And the other reason the courts apply this doctrine narrowly is because of the existence of force majeure clauses. A lot of the time, those clauses will cover the party's situation adequately. However, the relevant force majeure clause definitely has to apply this to the scenario before frustration will be viewed as inapplicable. For example, if you have a force majeure clause which lists a number of situations like the ones Ben was describing. So for instance, strike or war. There may be a number of scenarios prescribed, but if, for instance, it doesn't mention a pandemic or governmental intervention, there might be a role for frustration to play. I'll come on later to the COVID-19 implications, but we can already see that the doctrine of frustration is actually quite important and should be borne in mind when we're looking at any contractual situations. And it's also important to remember as part of our general legal learning. Next slide, please. So what approach does the court take when it's working out whether the doctrine of frustration applies? It adopts what it calls a multifactorial approach, simply meaning there are a number of factors that it needs to address. So firstly, the court will consider the terms of the contract, of course, and in particular, the existence, if any, of a force majeure clause. Secondly, the matrix or context of the contract, so the surrounding circumstances when the contract was entered into. Thirdly, the parties' knowledge, expectation, and assumptions, especially in relation to risk when they entered their contract. So the court will look at what the parties' understanding was, especially as to how they were going to allocate their different risk responsibilities. Again, taking the example of the international sale of goods, the seller takes on a certain risk in sending out the goods from the port and across the seas, for instance, about whether they're going to get paid. The buyer takes the risk of whether they're going to get the goods. So there are different risk allocations, as in all contracts. That's just one example. And then the next factor the court considers is the nature of the supervening event. Is it war, strike, famine, plague, governmental intervention? These are the types of events that the court will have in mind. And again, they're similar to the force majeure events or clause events. They need to be radically different from what the parties understood when contracting. And finally, the parties' calculations as to future performance. So what they anticipated in terms of their performance obligations. So that's the multifactorial approach. Then next, there's a methodology for categorizing frustration analysis. And you can divide it between frustrating events and frustrated contracts. Of course, there's overlap between these two things, but this is a neat way of encapsulating frustrations application. So as regards events, as we've already alluded to, there could be a change in law or some supervening illegality. So something that was previously lawful becomes unlawful and therefore frustrates performance under the agreement. There could be the requisitioning of the subject matter of a contract by the government. So what that means is if you're in the business of producing a particular item, and the government says, due to these extreme situations, for instance, war, we need to take all those products for the good of the public. That's a requisitioning situation. You would never have anticipated as a business owner that that was going to happen. Cancellation of events is another good example, also relevant to force majeure, as Ben has mentioned. War, I've already talked about, but crucially, hardship or financial loss will not be regarded generally as frustrating events. Ben has already talked about those in the context of force majeure. Equally, they are not typically regarded as frustrating events, but as I'll come on to query how they will be dealt with in future in the context of COVID-19. So that's categories of frustrating events. And secondly, the types of contracts we might look at. So as examples, contracts for the sale of goods, as I've mentioned, charter parties, and building and construction contracts are just some, of course, of the many different types of contracts that could be affected. Next slide, please. Lastly, in terms of frustration principles, we need to think about the impact. As I've said, the effect of the doctrine of frustration is to bring the contract to an end automatically. So the parties are excused going forward from performing any further obligations under the contract. There is a piece of legislation in England, which is mirrored actually in some jurisdictions in Australia as one comparison. It's called the Law Reform Frustrated Contracts Act. and it covers particular consequences arising from the application of the law of frustration. If a court says this contract is frustrated and it comes to an end, some parties could lose out from this. For instance, if you've already made a prepayment, like a deposit under a contract, and suddenly the contract is brought to an end by the court, you might want to see if you can recover that payment in respect of a contract that's no longer going to go ahead. And this legislation caters for those sorts of situations, amongst others. So it's quite important. Right, so those are some of the key principles in relation to the law of frustration. I might just say at this moment, though perhaps one of my co-speakers was going to mention it, the three of us have produced a paper on this, which is up on the Fountain Court website and has also been published in the New Law Journal. So if you're particularly interested in this area, you're able to find even more detail on this. I'm mentioning that while I think of it. So those are the key principles regarding the law of frustration. Now let's think about their application in the context of COVID-19. Firstly, thinking about that test we talked about, physical or commercial impossibility, there's a question as to whether COVID-19 has made it physically or commercially impossible to perform a contract or change the obligation to something that is radically different from that contemplated. Can you satisfy that test? And it will be very dependent on what has occurred in each situation. Has the disease itself forced the closure of premises? Or has the disease in turn caused the government to impose lockdown orders which have affected the operation of your business? Does all that make it radically different, or your performance obligations radically different? As we've been alluding to, if it's just a bit tougher for you to perform, there may not be frustration. But if, for example, you've been operating a business that produces particular things and as I've mentioned before, the government comes along and forces you to start producing something else, for example, face masks or ventilators, that can have a massive flow-on effect to your other contractual obligations with other parties. So maybe that could count. So the key is, how will the core test be interpreted in the context of COVID-19 claims? Next slide, please. Three more implications that I've mentioned here. The interaction with force majeure. So yeah, you might have a force majeure clause which covers pandemics or governmental intervention. It might completely cover the scenario in question, in which case you're fine. But equally, there may be a role for frustration to play if your force majeure clause doesn't cover COVID-19 scenarios. But just to remember, there are different impacts arising from, on the one hand, force majeure clauses, and on the other hand, frustration. With a force majeure clause, it's not necessarily all or nothing. The force majeure clause might say your obligations are paused or you're temporarily excused. And Ben mentioned some of the consequences. By contrast, frustration is all or nothing because the contract is brought to an end all of a sudden. So that's another area, interaction with force majeure. Next, the types of frustrating events. So a pandemic like COVID-19 could be a frustrating event, but the actual real cause might not be the pandemic, but its consequences. So lockdown, as I've mentioned, governmental requisitioning or cancellation of events, particularly, for example, sports and arts, as we've seen. So there's different types of events that may be relevant. And then I've lastly mentioned limits of frustration. So any force majeure clause that may limit the use of the doctrine of frustration in the context of 19. And we've talked about that. And similarly, there's a concept of self-induced frustration. So if you have brought about your own harm, the court will not be very sympathetic. So for instance, if the court has said, you must obey these lockdown orders and you disobey them, and that has follow-on losses, it's going to be a lot harder for you to be able to rely on frustration as a doctrine. Next slide, please. So I think just due to time constraints, we'll go through the next section quite quickly, We're going to mention briefly some of the implications for particular industries. I'll cover trade and supply chains and aviation. Patricia will look at banking and pharmaceuticals, and then Ben will turn to energy and insurance. Very briefly, one can see how the interplay of force majeure, frustration, and COVID-19 could have implications for the trade and supply chain world. Supply chains will have broken down in all sorts of industries, particularly food and beverage, but all manner of other things. If, for example, in the milk industry, dairy suppliers have been affected, that affects their contracts with the manufacturing organizations, which put the milk in a form to be distributed to wholesalers and onward to retailers. All those chains have been disturbed by COVID-19 and the changes in supply and demand. Similarly, in the aviation world, if you have aircraft leasing obligations, as just one example, they will be hugely affected, and one might end up trying to rely on a force majeure clause or a frustration clause in order to escape obligations, or on the other hand, dismissing those doctrines and trying to enforce them. Construction is, of course, another area that's hugely affected by this. So I'll keep those comments brief to allow my colleagues time to talk about implications in their sectors. So Patricia, onward to you.
Thank you. Yes, banking. Well, there are a number of ways in which it may be relevant. For example, banks may have taken security over underlying contracts relating to manufacture, supply, or lease. And those underlying contracts may incorporate a force majeure clause. So if that clause is triggered, that's going to have an impact on the value of the bank's security. And that in turn may then trigger a breach of the covenants in the loan facility, entitling the bank to call in the loan. More directly, obviously, COVID-19 may affect the borrower's ability to repay, although, of course, as we've identified, economic hardship as such in the classical English analysis is rarely going to itself be a force majeure event excusing the payment obligation. More likely in terms of the drafting of a typical bank facility, rather than economic hardship excusing the borrower, it is likely instead to be a material adverse change entitling the bank to call in the loan. One of the issues I think we're seeing in the UK jurisdiction is the possibility that the regulator may intervene to prevent banks behaving unduly harshly towards companies who are adversely affected by COVID-19. And of course, there is also for banks a reputational risk if they insist on their strict rights in this scenario. Otherwise, the pharmaceutical sector, well, there what we're seeing, I think, is a triggering of really massive fluctuations in demand and supply for particular products. To take an example, when President Trump extolled the benefit of hydroxychloroquine as a remedy for COVID-19, that of course triggered a massive spike in demand for that, such as to make it difficult to fulfill contracts directed to its normal application. And now we're seeing that spike subside. Many of the ingredients that are used in the sector come from China and India, so will have been affected by supply chain issues due to lockdown. But the classic English law analysis would say just because it's more expensive or more difficult to get the necessary ingredients, that doesn't release you. It's all a matter of degree and whether the contract has become radically different. In that respect, AIFC's Regulation 84B is interesting because it may potentially present a lower threshold for a party being released by that type of difficulty. I think Ben's going to deal next with energy and insurance.
Thank you. Just briefly on energy and insurance. Energy is one of the sectors that's been most obviously and most heavily affected. And the simple reason for that is that nobody's doing anything. So we all are staying home. The aviation sector is effectively closed. Nobody's driving anywhere. Apart from those who watch the English news, someone called Dominic Cummings you may have heard of. But anyway, other than him, everyone else has stayed home. What does that mean? It means that no consumers are buying petrol. So what does that mean? Well, imagine a supply chain from end producer of petrol to wholesaler. Wholesaler is obliged to purchase X amount of petrol, but no one wants to buy their petrol. The wholesaler is then stuck in a difficult situation. Is that a force majeure event or not? Under Regulation 84B, quite possibly yes, because there's a huge economic downturn or economic impact. Under normal principles, quite possibly no. So that's an interesting question. That's one example. Insurance policies are just contracts. They tend not to contain force majeure clauses. In fact, I'm not aware of any that do, at least in direct insurance. But insurance provides, if it's written on this basis, two types of cover that are directly relevant. One is called business interruption insurance, and another is called event cancellation insurance. Both of those, at least in England, and I think all over the world, particularly in the US, have given rise to huge litigation already. And in fact, there's a large market-wide dispute proceeding in court in relation to BI clauses, but in relation to cancellation cover, think of all the events that have been cancelled: Wimbledon, the tennis tournaments around the world, possibly the Olympics, etc., etc. Those were all insured, and so there's a lot of money at stake under that kind of cover as well. So that's a snapshot of the different sectors that have been affected in their different kinds of ways. And I'll just pass back to Deborah now, please. Next slide, please.
Yes, so very swiftly, just some quick comparisons with other jurisdictions. Singapore, for instance, has principles regarding force majeure and frustration. In the context of COVID-19, it's taken some significant measures where certain types of contracts will come into a new regime: supply contracts, construction contracts, certain trade finance instruments, performance bonds. They will be governed by this new regime where there will be a moratorium, so a stopping of claims in certain scenarios. And you can bring your dispute to a particular panel which will adjudicate on it. You're meant to avoid the general court system. You're not allowed to bring lawyers along, though doubtless people have legal advice in the background. The principles say that they will not exclude the law of frustration and force majeure, but this is quite an interactive and interventionist approach to frustration and force majeure type scenarios in the context of COVID-19, which is interesting. Contrast the position in England, for example, which is very much based around the autonomy of the parties, their independence to create contractual obligations. The doctrine of force majeure is still centered around the parties' ability to craft their own outcomes. And similarly, frustration will only intervene rarely. And when one looks at the UK's latest words on COVID-19, which you can find if you go to that link later on, essentially the UK is saying, when you're dealing with your contracts, be considerate of one another. And that's pretty much as far as it goes. That's what it comes to when you boil it down, which is in contrast to the Singaporean situation. And no doubt there'll be interesting points of comparison and contrasts with, say, civil jurisdictions, but we've just mentioned that as one example. Next slide, please.
Well, whilst I think your questions are being collated and sent through to me, this is where we're going to switch to interactive mode, and I'm going to get you started with a guessing game. So I'm going to give you the facts of a case that was decided in the English courts last month, where the court had to construe and apply a force majeure clause. And I want you to listen to the facts and then vote for whether you think performance would have been excused on grounds of force majeure. Okay, so are you ready? The case related to a subsidiary of the BBC, whose business was to market DVDs and CDs of BBC programmes. And the subsidiary brought a claim against the company which owned and operated a warehouse where all these DVDs and CDs had been stored. In August 2011, there was widespread rioting in London following an incident where an individual was shot by police. And during those events, a group of young men broke into the warehouse and set it on fire. And that fire raged for 10 days and completely destroyed the warehouse and everything in it, including all of the BBC's DVDs and CDs. The issue for the English court was whether the warehouse owner was liable for not having kept the DVDs and CDs entrusted to its custody safe, or whether it was excused by a contractual force majeure clause. Can we have the next slide, please? Thanks. So there is the clause for you. Neither party shall be liable for its failure or delay in performing any of its obligations hereunder if such failure or delay is caused by circumstances beyond the reasonable control of the party affected, including, but not limited to, industrial action at either party, fire, flood, wars, armed conflict, terrorist act, riot, civil commotion, malicious damage, explosion, unavailability of fuel, pandemic, or governmental or other regulatory action. So you'll see there reference to, among other things, fire and civil commotion and riot. So in this scenario, get ready with your voting buttons, people. Do you think that the warehouse owner would have been able to rely on that force majeure clause to escape liability? If you think they would have done, vote yes. If you think the warehouse owner would not have been able to rely on that clause, vote no. So I'll give you a moment to get voting. Almas, have we got the poll displayed? So yes, if you think that the clause would have allowed the warehouse owner to escape liability, and no if you think they would not have been able to rely on the clause. I'll give you a moment to keep voting, and meantime, Almas, if you have other questions to feed through, perhaps send them through to me on the chat, and we can come to those when we've dealt with this example.
Yeah, Patricia, I have sent you directly to you some questions from the guests.
Okay, let's give people a little moment to finish their voting. Sorry, I'm just looking to see whether questions have come through in the meantime. I think I can see one question that's come through directly to me, Almas. I'm not sure I can see any others.
I'm sending.
Okay. Let's move on then in terms of our example. Now, I'll admit that I have cheated a little bit because there are some facts that I didn't give you earlier. It was common ground that the riots in August 2011 were themselves unforeseen and unprecedented, so far so good. Police shootings are not a regular occurrence in England, and neither the shooting nor the reaction to it were foreseeable. So the context was indeed one of civil unrest, including malicious damage to property, which was unforeseeable. But if we approach the matter not in terms of the particular motivation for breaking in or for the riots, but rather foreseeability more generally, the fact is that break-ins into a warehouse or fire are, in general terms, foreseeable risks. In fact, the risk of intruders was not just foreseeable, but there had been earlier break-ins at that particular warehouse. The risk of arson, the risk of the destruction of a warehouse by fire is in general something that a warehouse owner needs to be aware of and is foreseeable. The attack on the warehouse could have been prevented by better security at the warehouse, and even if the youths had managed to break in, the severity of the fire itself would have been less had there been better fire precautions, for example, a sprinkler system. Now, on that basis, the damage to the BBC's property was not an event outside the warehouse owner's control. And of course, you'll recall that fundamental to the concept of force majeure is the event being outside your control. Here, although the rioting was outside the control of the warehouse owner, the consequences for the stock in the warehouse was within their control and could have been avoided by better security measures and better fire precaution measures. So the conclusion there was that the warehouse owner remained liable. If the same problem came before the AIFC court applying Regulation 82, I suggest that the court would reach the same conclusion, because you'll recall that regulation includes that the party relying on force majeure could not reasonably have been expected to have taken the impediment into account either at the time of contracting or to have avoided or overcome it in terms of what's done afterwards to avoid the consequences. So let me see how you did on the poll. And congratulations, because the majority of you thought that the warehouse owner would not have been able to rely on the clause, which is indeed the answer that the English court came to, and I think it would be the answer that the AIFC court would be likely to come to as well. Now let's see where we're getting to in terms of questions. Right, okay, I think I've got those now. From Mr. Almaz Bekeshev, advocate. My question is, how do parties prove a case of force majeure in common law jurisdictions? What could be the evidence of that? Ben, do you want to tackle that one first?
Yeah, sure, absolutely. So in the usual way, the standard to be met is balance of probabilities. So the evidence is designed to reach that threshold. And obviously the more extreme the allegation, generally speaking, the more convincing the evidence has to be. But in the current circumstances, there are elements of the test that could be relatively easy to make out. So if you start first with, imagine that there's a clause covers pandemic as a force majeure event, it will be relatively straightforward to demonstrate that there was a pandemic, depending on the timing. But the more difficult question in these kinds of cases will often be causation. So what actually caused the inability to perform, for example, was the party seeking to rely on the clause prevented from carrying out their side of the bargain? Now that as I infer the question was getting to, is more difficult. And that will require convincing evidence of whatever type the sector is affected by. So to go back to, for example, the petrol example I had, imagine that economic downturn was covered. Well, how do you prove that you're in dire financial straits because nobody wants to buy your petrol? Well, you take the demand side of your business from prior to the downturn, and you demonstrate that through your purchasing records, through your financial accounts and so on. And then you show the court, well, look at it now. And obviously there's then a matter of inference for the court to draw. Well, what happened in between those two time periods when you were doing so well and you had 1 million customers, down to you're doing appallingly badly and you've got 5 customers? By inference, it's the pandemic. And obviously the way to demonstrate on the facts will vary from case to case. That is one example, but the difficult element will often be the causation element.
If I might add to that, because it may be particularly relevant to those doing business in your part of the world, one knows that some jurisdictions, and China is an example, have been issuing certificates to exporters to the effect that they have been affected by a force majeure event. But certainly the approach of the English courts would not be to take a certificate like that as in itself probative. It would not release the party from having to prove by evidence that it had in fact been affected by a force majeure event, by the types of evidence that Ben is describing. Now, moving on, I think Alexei Martinov, head of legal department in CAS Business Consulting, I think your question was in many ways quite similar, asking whether we've been engaged in any court proceedings on the grounds of force majeure and what can be done to succeed with the case. I think, broadly speaking, Ben has answered that question in terms of the types of evidence that one would need to produce, certainly that an English court would expect to see, and I would expect the AIFC court, given the background of the judges who sit there, to require very similar types of evidence by way of proof. Can I turn therefore to the question we have from Shahzad Nazarov, a lawyer at the Uzbek bar, who says the state of emergency is considered as a reasonable ground for non-performance, but what if a state of emergency is not announced in the country? Could I rely on the World Health Organization's announcement on pandemic? Deborah, do you want to comment on that?
I'd have thought, subject to the particular facts, the answer might be yes. So certainly the World Health Organization's announcement that COVID-19 is a pandemic should be of some significance. But I think the next question will be, well, what particular impact has this had on you or your business? It is going to be very fact dependent. Even if there's not a state of emergency declared in a particular country, there might have been governmental advice or even some regulations made that might affect parties' performance obligations or ability to operate their business. So depending on the terms of those, that could have an impact as well. So a combination of factors like the ones I've just mentioned could influence one's approach to presenting evidence about the force majeure clause or frustration, as the case may be.
Certainly, for example, if you're dealing with a force majeure clause that expressly refers to pandemic, the WHO announcement would undoubtedly be sufficient for an English law court to treat that as triggered, regardless of what your own government in your own jurisdiction might have said. So it will all depend, I think, on the wording of the particular clause, or indeed, in this case, the particular regulation, if we're looking at the AIFC's regulations. Further question I think we have here from Akilbek Sultan Gazinov, self-employed. He says, as everybody may be aware of the predicted second wave of COVID-19, can we suggest how people will mitigate possible risks through their non-performance clauses? Now, Ben, you mentioned earlier, of course, that we are largely dealing with existing wording in contracts, but to the extent that parties have the luxury of being able to address how to mitigate their risks here and now vis-a-vis a second wave, are there any generalized tips that one can give, with all the usual caveats that they don't amount to legal advice in the individual situation?
Yeah, exactly. And without advising on any individual situation or giving legal advice, as no doubt many people on this Zoom meeting will have as well, I've seen lots of requests urgently for revisions to wordings. The first thing is many of the force majeure wordings don't contain pandemic wording at all. And many of them don't contain economic downturn or economic hardship wording at all. So that's one element. Another element is that they tend to be quite restrictive in terms of what the effect must be, i.e. the parties are prevented from doing A, B, and C. That can be expanded to, for example, hindered. They also tend to be quite restrictive in terms of causation. So there tends to be a sole cause element, or the wording indicates sole cause. Parties try to relax that. But there are major caveats to all of that. One is, for as good as a force majeure clause is, it's as bad, i.e. they cut both ways. So if you free up your wording, so you, the contract drafting party, is able to walk away from almost anything, frankly, because of almost any reason. Generally speaking, that applies the other way. And so you're causing yourself as much of a problem as you're creating a benefit. The second point is if you try to mitigate that by making it exclusively in your own favour and not in the favour of the other party, there is a potential risk that it's unfair. At least domestically in England, Section 3 of the Unfair Contract Terms Act may, depending on the circumstances, apply and then render all of your efforts undone. So there is a line to be trodden carefully, but understandably parties are doing everything they can to try to renegotiate terms or redraft them where they can.
I'm also wondering, Ben, just in conjunction with that, what impact governing law clauses might have, because they could make a huge difference potentially going forward, dependent on jurisdictional differences or differences between different countries on how they're approaching this sort of thing.
That's right. So, I mean, in the energy sector, a lot of wordings are standard wordings on standard terms, but with effectively a front sheet that then designates things like the specific clauses and in particular the choice of law and jurisdiction clause, which could radically change the impact of the otherwise standard wording.
I think we have one final question about the force majeure issues from Mr. Rustam, legal manager. And I think this one's for you, Deborah. He says, I would like to know if force majeure clause in the contract is very limited in terms of coverage. May I rely on frustration concept?
I think the answer to that is yes, again, subject to the facts and circumstances. So if your force majeure clause, as you've described, is very, very narrow in its application, then a logical step would be to consider the law of frustration and whether it's applicable to your particular circumstances. Again, you'd have to ask the sorts of questions that I outlined earlier. Has the event made it physically or commercially impossible for you to perform? And is the situation radically different from what was contemplated in terms of performance when the parties entered into the contract? So subject to those sorts of principles and the other ones I mentioned, then there may be room at least to look at the doctrine of frustration and see what role it may have to play.
Thanks. And in answer to Samal, student of Eurasian National University, I refer you to our website where you can see all the details set out about how you might apply for internships at Fountain Court. Okay, right. I think that's all the questions that we have set out from people. So thank you very much indeed for sticking with us, even though I'm afraid we have rather overrun our time. Very interesting questions from you, and I hope we have given you something to think about. And of course, given that as barristers, what we like doing most is arguing for a living, what we're really hoping is that your AIFC court is going to come up with a really interesting trial about one of these issues. And then in a year's time, we can come back and debate together whether we think they got it right or not. Okay?
So, Patricia Robertson, QC, thank you so much for moderating this event. Ben Lynch, Deborah Horowitz, thank you for your very insightful, relevant, and really cutting-edge discussions around some of these issues that have arisen around force majeure and frustration. So on behalf of the AIFC Academy of Law, we are really quite grateful for your time. We welcome you back anytime to continue with other interesting topics. And to our participants, thank you for your engagement, for your interest and your enthusiasm. So this ends the third segment of our Fireside Chat with AIFC Advisory Experts webinar series. Please join us next week, next Thursday, June 4th, which is the fourth component of that series. So stay safe, everyone. Stay well. I know it's only Thursday, but have a great weekend. And thanks to all again. Bye-bye.
Thank you. Bye.
Thank you.
Bye.
Bye.